Hello, welcome to Navigating Estate Planning with Caress Law. Today, I am going to talk to you about fiduciaries, what that word actually means, and who to choose for the position or the role, if you will. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. I'm Tammi Caress. I am founder of Caress Law, and we are an estate planning firm servicing clients in both Oregon and Washington. And I really hope this podcast serves you well. I like to choose the podcast topics based upon the many questions I get from my clients. And one of the questions I get is fiduciary, because in my documents, you'll see that word come up quite a bit. And a fiduciary is a person who is tasked with making decisions for, whether it's financial for a person, for finances, or over the person themselves. And they have an obligation to act in the best interest of that person. And when we're talking about estate planning, there's so many documents where we are appointing a fiduciary to step in and act upon incapacity, or step in and act when you pass away to settle an estate. So today I'm going to kind of go through some of those things and then also discuss who might be the best person for the role. So a few of the terms here that are fiduciaries are executor. Now, in Oregon and Washington, we call this person a personal representative, but so many people know what an executor means. So it's the same thing here. An executor or personal representative is someone you appoint under your will to settle your estate at your death. And they are tasked with many responsibilities. It is all a fiduciary. It's a fiduciary obligation, meaning they can't just take your assets and run. They have to follow the terms of your will. And that is the executor / personal representative. Another fiduciary role is a trustee of a trust. Many people out there, as part of their estate planning, have a trust that they have prepared. And in that, the trustee is the person responsible for protecting the assets owned by the trust and also following the terms of the trust on behalf of the trust beneficiaries. So this person, again, is a fiduciary, and they have to act in the best interest of the beneficiaries of that trust. Another fiduciary is an agent under a power of attorney. And there's lots of types of powers of attorney, and it's applicable to all. A power of attorney could be appointing a person to be responsible for your financial and legal matters in the event of incapacity. It could also be because you're out of town and you appoint someone a limited power of attorney to do a specific thing for you. When you make that appointment and that a person acts on your behalf, they are a fiduciary. They have an obligation to act in the best interest of, it's called a principal, the person who they're acting on behalf. The other is a personal a healthcare representative. So there is a healthcare power of attorney that's naming also an agent to direct your medical care when you cannot direct it for yourself. And we also have a term called healthcare representative, which is very similar. It's nominating someone to direct your medical care when you cannot speak for yourself. So again, there is a fiduciary obligation to act on the best interest of the principal who is making those nominations. And when I say nominations, it's because essentially when these documents are prepared, you appoint someone to step into these roles upon a triggering event, which usually is death or incapacity. And I say nominate because even though you've appointed someone in that role, they are not obligated to serve in that capacity. So just because you name someone in your will to settle your estate, they could actually decline to serve. And they have no fiduciary obligation until they've actually accepted that appointment. Okay, so I hope that's helpful to clarify what a fiduciary is. And now I really want to go through who to choose. And this is actually a super difficult problem for so many people out there, and I understand. It's a big role, and for the most part, I think a lot of people want to alleviate the burden upon their family members in some way or another, and they feel guilty about choosing someone to do this because they know it's a big task and a big responsibility. Nonetheless, it's still a good idea to do it because if you do not name someone as a fiduciary in for these certain documents to perform these certain roles, then a court will do it for you and you no longer have a choice. And it also is very expensive, by the way. So who do you want to serve as your fiduciary? This is an obvious one, but I'm going to say it anyway because it's super important. Someone you trust. You have to trust them. If you have a concern that they might dip into the bank account when they're not supposed to, or that they're not going to give your assets out under your will or trust as you described, that is not a good person to name. So you need to trust them. And remember, a fiduciary here, since we're talking generally, it can apply to different types of documents. It is also someone you are appointing to manage your own, or it can be someone you're appointed to manage your own finances where you're unable, or it's someone you're appointing to manage an inheritance that you're leaving for somebody else. So number one, make sure you trust that person. Number two, especially when it comes to your passing and you have multiple beneficiaries under your will or trust, a lot of times you have multiple children or grandchildren, you want to appoint someone who is an effective communicator. I oftentimes will tell my clients who we are helping administer an estate, I let them know, hey, if nothing has happened this week, go ahead and send an email out to everyone and let them know nothing's happened, because no news is news. You want someone who's going to communicate about what is going on. We're putting the house up for sale. We have cleaners coming over to clean out the house. We got an offer on the house. Any of those sort of details, it's just good to let your beneficiaries or appoint someone who's going to communicate those things, because oftentimes when I see families begin to fight, it might be because the person you've appointed is doing everything they're supposed to be doing, but they're not communicating it to the rest of the family members. And then that's when others get suspicious. So an effective communicator is super important. The other trait, I would say, is you want to appoint a responsible person. And I know that seems super obvious, but I can't tell you how many times I have clients in my office who they appoint their children by the order of birth, not by whether one is going to do better at this job than another. And I think that is a huge mistake. But parents have this guilt about their kids, and they think, well, Joe is the oldest, he should do it, even though Joe he has trouble paying his own bills. And when I say trouble, it could be that he just pays them late. He pays them, but he pays them late. You want someone who pays their own bills on time. And it's much better to choose that second child who might be younger, who might be more fiscally responsible than another child who tends to pay their bills late all the time. So a responsible person. Now, this other one it's important. It's not always required. There's things that we can do to help the scenario if this is the case. But it's helpful to appoint someone who knows the family. Obviously, if they know, especially if there's special circumstances within the family, appointing someone who knows the family is going to be helpful because they're going to know the family scenario. If you appoint someone who has no idea about the family, it can be a little difficult to assess the situation, if you will, without the historical knowledge of the family. However, with that said, there are times when it's really good to appoint a neutral third party, and it could even be a professional who wouldn't know the family. And just as a side note, if that's the case, a lot of times I put another person in the document who kind of is the family liaison, if you will, and they really talk to and communicate with that professional fiduciary and help with that family historical knowledge. Okay, so another trait would be don't appoint someone who procrastinates. When you pass away and we have to settle the estate, there are certain things that need to be done. And the longer they wait to do them, the more expensive it gets. And you're leaving, and the more opportunity, if you will, for family members to not get along, frankly. So someone who procrastinates, not always the best in a fiduciary kind of role. And then another trait is someone who is assertive. And what I mean by assertive, I don't mean, a bully or anything like that. It's more or less someone who can look at your documents and say, well, this is what they wanted me to do, and this is what I'm going to do. And if they have a beneficiary that's in their ear wanting, money out sooner or wanting something beyond what the trust or the will says, well, then you want someone who says, no, I'm sorry, I can't. I'm tied. My hands are tied. I have to follow what this will or trust says. If you have a person, or if you appoint a person who's going to be swayed, ultimately you're putting that person in the position to do something they're not supposed to do. And frankly, they can get into a lot of trouble if they don't settle the estate the way that it is written within your documents. So a person who's assertive, who's going to be able to stand up to beneficiaries who maybe want something sooner than they can get it, or more than what they're entitled to. You want someone who's going to be able to say no. Okay, well, that's my little task list here of when folks ask me about who a fiduciary should be. The other thing that I will just add to all of this, especially when we're dealing with guilt, because again, a lot of people appoint someone out of guilt, not out of who really will be the best in this kind of role, is just talk to them. Talk to your family. Let them know, hey, I appointed child 3 as my healthcare representative because child 3 lives a house over from me, and it's going to be quicker for them to get to me. Hey, I appointed child 2 because child 1 has 4 children of their own, and I just thought this would be too much for them. Whatever it is, communicating with your family so that they understand and they know who these people are, I think can really help alleviate some of that guilt. But then also when the time comes for that fiduciary to step into the role, they all understand and know the perspective and where you're coming from, and there's no surprises. Okay. Well, I'm going to direct you once again to my website. I do have a few blogs where I talk about this. I have one, I talk about power of attorney and how to choose the right agent. That one is really good. It is essentially, even though I'm talking specifically about a power of attorney, it's really applicable to all fiduciaries. So that's a good one to check out on my website. And I have so many other resources. The website is www.caresslaw.estate, and that is CARESSLAW.ESTATE. I hope this was helpful, and until next time.